Welcome back to Deb's True Crime Notebook, where we read the documents for you so you don't have to. We have a motion to strike state's response brought to you by Andrew Baldwin. Let's see what they have to say. Defendant's verified motion to strike the state's response to motion to correct error. The defendant, Richard Allen, by counsel, now comes before the court with his verified motion to strike the state's response to motion to correct error. The response, filed on February 4th, 2025, for the reasons that follow, the court should strike the state's response in its entirety from the record of this case. The state's response is unverified and, without supporting affidavits, asserts numerous facts outside the record in violation of Trial Rule 59H2, which provides, if a party opposes a motion to correct error made under this subdivision, that party has 15 days after service of the moving party's affidavits and motion in which to file opposing affidavits. See also Moretta versus Romero, 225 NE 3D 199205-06, Indiana Court Appellate 2023. A motion to correct error under the trial 59H1, unsupported by affidavits, presents nothing for the court to consider. In particular, on page 2 of the state's response, Mr. McClellan alleges, on November 3rd, 2022, the state received an email from attorney Brett Gibson stating that he would not be representing the defendant herein attached as State's Exhibit 3. The allegation is based on facts outside the record and unsupported by affidavit or verification in violation of Trial Rule 59H2. On pages 7 through 8 of the state's response, Mr. McClellan alleges the defense received the van video and any information pertaining to Ron Logan included in Mr. Allen's motion to correct error on January 30th, 2024. That allegations Mr. McClellan asserts is supported by State's Exhibit 7, a discovery release. These allegations are based on facts outside the record and unsupported by affidavit or verification in violation of Trial Rule 59H2. On page 8 of the state's response, Mr. McClellan says Ricky Davis was interviewed by law enforcement, which he was, as shown by defendants' exhibits 4A, 4B, and 4C. But Mr. McClellan also says Mr. Davis requested a polygraph examination, which he failed miserably. No exhibit of Mr. Allen says anything about a polygraph examination. These allegations by Mr. McClellan are based on fact outside the record and unsupported by affidavit or verification in violation of Trial Rule 59H2. Similarly, on page 8 of the state's response, Mr. McClellan says that Ron Logan told Mr. Davis he moved the cell phone battery from the girl's phone and left the phone behind, and that he took the girl's clothing from the scene and burned them. Nothing in any of Mr. Allen's exhibits pertaining to Ron Logan's confessions to Mr. Davis says anything about Ron Logan removing a battery from any phone. Similarly, nothing in Mr. Allen's exhibits pertaining to Ron Logan's confessions to Ricky Davis say anything about Logan burning the girl's clothes. These allegations by Mr. McClellan are based on facts outside the record and unsupported by affidavit or verification in violation of Trial Rule 59H2. The following are footnotes at the bottom of this page. 1. The tip in the Orion database, Defendant's Exhibit 4A, does recite Logan told Ricky how he burned his clothes in the fire pit and where it was located. Emphasis added. See also Defendant's Exhibit 4B at page 3. Burned his clothes in the burn pile. Emphasis added. But again, nothing anywhere says anything about Mr. Logan confessing to taking the battery out of a phone. While the court might take Mr. McClellan's misstatements of fact about the burning of the clothes as simply a mix-up on his part, either Mr. McClellan is making up the allegations about Logan removing a battery from his phone out of the whole cloth, or he has access to information about Ron Logan's confession to Ricky Davis he has not shared with the defense. In either event, there is a reason Trial Rule 59H2 requires affidavits in support of the response to a motion to correct error when that response is based on evidence outside the record. Also on page 8 of the state's response, Mr. McClellan says, no evidence places Ron Logan at the scene of the murders. This allegation by Mr. McClellan is based on facts outside the record and unsupported by affidavit or verification in violation of Trial Rule 59H2. On page 9 of the state's response, Mr. McClellan says Sergeant Cecil was able to observe photos of the phone when it was found herein attached as State Exhibit 9, 10, and 11. In addition to not saying whether Sergeant Cecil actually observed those photographs, this allegation by Mr. McClellan is based on facts outside the record and unsupported by affidavit or verification in violation of Trial Rule 59H2. Also on page 9 of the state's response, Mr. McClellan alleges that Sergeant Cecil's testimony that the log entry on Libby German's phone reflecting the headphone behavior could have been caused by a malfunction due to dirt or water in the headphone jack was based on his knowledge and experience as a forensic phone examiner. Sergeant Cecil's trial testimony about the possible effect of dirt or water in the headphone jack was based entirely on a Google search performed during a break in Mr. Allen's trial. The allegations that Sergeant Cecil's opinion then had anything to do with his knowledge or experiences based on facts outside the record and unsupported by affidavit or verification in violation of Trial Rule 59H2. 2. The court might want to consider whether to hold Mr. McClellan in direct criminal contempt for publicly filing crime scene photographs the court ordered sealed at Mr. McClellan's own request. See Hopping v. State, 637 NE2D, 1294, 1297, Indiana, 1994. Whereas here, the court has first-hand and immediate knowledge of acts demonstrating a clear disregard for its authority, which threaten to undermine the integrity of the judicial process, summary proceedings for direct criminal contempt are available. See also ID at 1296. The power of Indiana courts is to summarily punish for direct criminal contempt while specified by statute rest upon the common law. It is inherent in the courts. Alternatively, under Indiana Code 34-47-3-1 and 34-47-3-5, the court might consider issuing a rule to show cause why Mr. McClellan should not be held in indirect criminal contempt for his willful violation of an order of this court. On page 10 of State's response in subparagraph 4L, Mr. McClellan says, there is nothing in the logs, reports, or extractions that would indicate whether or not the phone had some kind of water damage because that kind of damage is not registered in the logs, reports, or extractions of the phone. Whether or not there was water damage can only be determined by physically examining the phone. Mr. McClellan is not an expert and attempts here to testify as if he were one. This pleading is not his first attempt. Every single allegation of this subparagraph quoted above is based on facts outside the record and unsupported by affidavit or verification in violation of Trial Rule 59H2. All the allegations above, based on facts outside the record and unsupported by the affidavits or verification, are crucial to the state's response because the absence of supporting affidavits or verification by Mr. McClellan violates Trial Rule 59H2. The state's response should be stricken in its entirety from the record of this case. In addition to alleging facts outside the record of this case, without supporting affidavits or verification of the facts in his own motion, Mr. McClellan repeatedly mistakes the law and therefore misleads the court. On page 2 of the state's response, Mr. McClellan says the statute governing safekeeping orders, Indiana Code 35-33-11-1, does not require the court to have a hearing to make this determination. The court can make this determination based on the motion alone. He repeats the assertion on page 3, saying Judge Diener was within the jurisdiction of the statute to make a ruling on the safekeeping motion without a hearing. But this cannot be so because, as set out in Mr. Allen's verified motion to correct errors on page 6, under the next section, Indiana Code 35-33-11-2, Mr. Allen had an absolute right to refuse the transfer to the Department of Correction because then Sheriff Lesenby had only alleged the safekeeping request was to protect Mr. Allen's personal safety. How could Mr. Allen have exercised his statutory right if the court could make factual findings based on then Sheriff Lesenby's motion alone? He could not have, of course, and Mr. McClellan's interpretation, for the lack of better word, of the statute is completely unsupportable. On pages 5 through 6 of the state's response, Mr. McClellan says the presumption of prejudice from United States versus Chronic 466 U.S. 648 1984 is only applied in cases of non-representation throughout the entire case. Smith versus Brown 764 F3D 790 7th Circuit 2014. Apparently, Mr. McClellan is unacquainted with footnote 25 of Chronic, which unambiguously says the court has uniformly found constitutional error without any showing of prejudice when counsel was either totally absent or prevented from assisting the accused during a critical stage of the proceeding. Chronic 466 U.S. at 659 N25, citations omitted. And Smith versus Brown, the 7th Circuit case Mr. McClellan relies upon, says nothing different in Chronic the court. And again, we have footnotes at the bottom of this page. 3. The state's response does not explain how there was even any evidence before Judge Diener from which he could make a factual finding without a hearing to support his safekeeping order, because then Sheriff Lesenby's motion was unverified. 4. At pages 2 and 3 of the response, without denying that he knew Mr. Allen was represented by Brett Gibson, Mr. McClellan attempts to make much of Mr. Gibson not having filed an appearance for Mr. Allen on page 3. For example, the state's response says, as of the filing of the motion for safekeeping, the defendant did not have an attorney of record. This complaint should strike the court as odd because Mr. McClellan appeared at Mr. Allen's initial hearing on October 28, 2022, and filed the state's verified request to prohibit public access to a court record the same day, with no service of that motion on anyone, of course, even though he knew Mr. Allen was represented by Mr. Gibson. And on November 22, 2022, Mr. McClellan both filed his request for what became known as the gag order and appeared for the state at the hearing on his request to prohibit public access to a court record. But Mr. McClellan did not file his own appearance in this case until the next day, November 23, 2022, almost a month after he initiated the case. It is apparently enough having an appearance on file, but it is insufficient for Mr. McClellan and then Sheriff Lesenby at the first least to have known Mr. Allen was represented by Mr. Gibson, regardless of Mr. Gibson's not having filed an appearance, and somewhat warned saying about glass houses should come to mind. Explain that presuming prejudice would be appropriate in the face of a complete denial of counsel or denied at a critical stage of the litigation. Smith 764 F3D at 796, citing Chronic 466 U.S. at 659. It really is debatable that Mr. McClellan has, at best, misunderstood Chronic. Our recent cases make clear that, contrary to the Court of Appeals' conclusion below, denial of counsel at any critical stage of the criminal prosecution in per se constitutional error, Thomas versus Kemp, 479 U.S. 996, 999, 1986, emphasis added. On page 6 of the state's response, Mr. McClellan calls the Van video defendant's Exhibit 3A, at best, impeachable evidence. That is not so. Agent Pohl's testimony about a prior inconsistent statement by Brad Weber would have been merely impeaching. The van video is substantive evidence of when Brad Weber arrived home in his van. See E.G. Pritchard v. State, 810 NE2D 758-761, Indiana Court of Appeals, 2004. Under the silent witness theory, video recordings and photographic evidence may be admitted as substantive evidence. Accord Carter v. State, 956 NE2D 167170 N6, Indiana Court of Appeal, 2011. Trans denied. More importantly, on page 6 of the state's response, Mr. McClellan's erroneously asserts that a motion to correct error only applies to newly discovered evidence. Actually, Trial Rule 59H, by its own terms, provides for motions to correct error based upon evidence outside the record. The rule says nothing about newly discovered evidence. Defendant's Exhibit 3A, the van video, is evidence outside the record, and Mr. McClellan has no answer to Mr. Allen's claim under NAPU v. Illinois 360 U.S. 264. We're going to take a break here and go back to the footnotes, and we'll continue with the document in just a second. So under footnotes, also on page 6, Mr. McClellan says Defendant's Exhibit 3A, the van video, is in the form of a YouTube link that is not identified as an item of evidence by an Indiana State Police number and therefore is an improper submission for consideration by the court. In fact, as Mr. McClellan must know, Mr. Allen properly filed the video file that is Defendant's Exhibit 3A with the court on a thumb drive. Mr. Allen also properly served the state with the exhibit in the same way. The web link was provided in Mr. Allen's motion to correct error simply for ease of viewing by the parties and the court, and Mr. Allen is unaware of any requirement that his exhibits be identified by an Indiana State Police number, especially when the video recording was provided to the defense. Again, Mr. McClellan must know without such a number. And back to the document, that from the van video in his possession, Mr. McClellan knew or should have known that Brad Weber's testimony, critical to the state's case as presented to jury, that he arrived home in his van at about 2:30 p.m. on February 13, 2017, before Libby German's cell phone stopped moving at 2:32 p.m., was false, and 2, Mr. McClellan did nothing to correct Mr. Weber's testimony. NAPU 360 U.S. at 269. A conviction must fall when the state, although not soliciting false evidence, allows it to go uncorrected when it appears. Citations omitted. See also Civic versus Hardison, 658 F3D 898 909, 9th Circuit, 2011. It is irrelevant whether the defense knew about the false testimony and failed to object or cross-examine the witness, because defendants cannot waive the freestanding ethical and constitutional obligation of the prosecutor as a representative of the government to protect the integrity of the court and the criminal justice system. Cleaned up. Everything above about Defendant's Exhibit 3A, the van video, applies equally to Defendant's Exhibit 3E, an FBI subject information sheet for Brad Weber, which shows Mr. Weber's cell phone first began pinging at his family's house at 2:50 p.m. on February 13, 2017. On page 7 of the state's response, Mr. McClellan says the subject information sheet for Mr. Weber is not newly discovered evidence and, at best, impeachable SIC evidence. Defendant's Exhibit 3E is substantive evidence of when Mr. Weber returned home in his van, and because it was in the state's possession, Mr. McClellan either knew or should have known Mr. Weber's testimony that he returned home at 2:30 p.m. was false. And as with the van video, Mr. McClellan did nothing to correct Mr. Weber's false testimony. 6. Mr. McClellan seems to be under the misimpression that all his evidence is substantive, while contradictory evidence presented by the defense is merely impeachable. This is of a piece with his idea that actual cell phone data showing headphones were plugged into the unplugged from Libby German's cell phone hours 2:32 p.m. indicates that data was caused by dirt or water damage, all because the data would otherwise disprove the entire case he presented, and everyone is to assume that the case must have accurately portrayed what happened. See State's response at page 9, subparagraph 4J. Finally, the one affidavit Mr. McClellan does have supporting the state's response is State's Exhibit 5, executed by Tobe Lesenby. The problem with that is Lesenby's affidavit directly contradicts at least twice his sworn testimony at the safekeeping hearing held on June 15, 2023. First, in his affidavit, Lesenby says that Mr. Allen was transferred to White County Jail on October 28, 2022 because of overcrowding at Carroll County Jail. State's Exhibit 5 at 4 at the safekeeping hearing in June 2023. Lesenby explained Mr. Allen's transfer to the White County Jail as follows. Question: and so tell the court what arrangements you made to have him placed in White County? Answer: just a matter of simply having direct communication with Sheriff Bill Brooks and explaining my concerns of potential safety and security of our facility and ask him if he could temporarily hold Mr. Allen for us. Question: okay, and you were confident that Mr. Brooks and his facility was not adequate to hold or was adequate to hold him on a temporary basis? Answer: at that time, yes. TR at 16. There is not a word about overcrowding at Carroll County Jail being the reason for Mr. Allen's transfer to the White County Jail. In his affidavit, Lesenby also says that Judge Diener at no time gave me legal advice on the motion pertaining to safekeeping. State's Exhibit 7 at 7. In the first instance, Lesenby is not competent to say whether Judge Diener gave him legal advice. In the second, Lesenby ambiguously said Judge Diener adjusted the language in Lesenby's safekeeping motion. Question: all right, and is the motion that I've just alluded to that was filed by you, signed by you, and filed back in November 2022? Answer: yes, sir. Question: did you draft this motion yourself? Answer: actually, I had presented a similar motion to court, and as I recall, the court had actually come up or provided this particular document. Question: okay, so let me see if I can ask a more direct question. Did you prepare that motion in your office on a computer, essentially? Answer: I prepared a similar motion to this. Again, the wording was adjusted by the court. TR at 11. Judge Diener also asked Lesenby to sign the safekeeping motion, which Lesenby did. TR at 12. Leaving aside the improper ex parte communications between Judge Diener and Lesenby, adjusting the wording of a motion to be filed in his court and on which he would be ruling obviously constituted both reviewing and drafting a document, which Indiana Judicial Conduct Rule 310 prohibits, except when done for family members. And reviewing and adjusting the wording of a motion is most fundamentally the giving of legal advice, which Rule 310 also prohibits. See in reference Hill 969 NE2D 11, Indiana 2011. Respondents admits the Commission's allegations that his letter advised the couple on legality and effectiveness of the documents he had reviewed. This constitutes the practice of law by giving legal advice. Mr. McClellan solicited then from Mr. Lesenby an affidavit saying Judge Diener had not given legal advice when Mr. McClellan knew or should have known that was simply not true. That is not all the different from letting Brad Weber's false testimony go uncorrected. In sum, in violation of Trial 59H2, the crucial facts on which State's response depends are outside the record and are unsupported by affidavit or even verification of the response itself by Mr. McClellan. The State's response also pervasively misstates the law and therefore misleads the court. Finally, the one affidavit the State did submit in support of its response alleges facts Mr. McClellan knew or should have known are not true. For all these reasons, the court should order the State's response stricken from the record. Conclusion. For the foregoing reasons, Mr. Allen respectfully requests that the court strike the state's response from the record of this case and either vacate Mr. Allen's convictions or set his motion to correct error for a hearing. Mr. Allen also requests any other appropriate relief. Respectfully submitted, Andrew J. Baldwin. And that is the defendant's verified motion to strike the state's response to motion to correct errors. Boy, that title is a mouthful, isn't it? Mr. Baldwin does like to write, I'll give him that. We'll have to wait to see what happens here, a response from the prosecution on this. Is it a matter of linguistics, fire pit, burn pile? Does that really matter? Also, there's just little details that could be Mr. McClellan knows something that the defense did not find in the information that they were given. That has happened before. It's a possibility that the prosecution could be incorrect on some things. I'm not really sure. To me, a lot of it seems like it's mincing of words. And so we'll have to wait for a response back or a response from the judge and let you know what happens then. Thanks for listening. We'll see you next time on Deb's True Crime Notebook. Don't forget to like, subscribe, ring the bell for all notifications, share this with your friends and in a group, and leave us a comment. What do you think? What do you think is going to happen next? And when you leave a comment, please do so respectfully. State your opinion, state your facts. Do it without making a derogatory comment towards anyone, including me. Let's try to be kind. We'll see you next time on Deb's True Crime Notebook.